Hi, so if you're watching this video, it means that you're interested in family-based immigration options to the United States. So maybe you have a sibling that can potentially sponsor you for a green card. Maybe you have a fiance or you're married to a US citizen or green card holder. Or maybe you have a parent or a child that could potentially sponsor your green card. Well, that's great news because in this video, I'm going to go over multiple options to get a family-based green card to the United States. So let's get started. As a quick overview, my name is Michael Ashoori and I'm a US immigration lawyer based in Los Angeles, California. At my law firm, we work with clients from all 50 states and worldwide. So we're going to start off by talking about a very popular immigration option right now, and that's a Fiancé Visa, also known as a K-1 visa. Now, how does the K-1 Fiancé Visa work? Well, the way it works is that if you are a foreign fiancé of a US citizen, the US citizen can petition, they can file immigration paperwork on your behalf so that you can eventually apply for a visa to come to the United States so that you both can get married in the United States. In order to qualify for a fiancé visa, you must be engaged to a US citizen. Also, both you as the foreign fiancé and the US citizen must be free to marry. That means that if you were previously married to somebody else, those prior marriages must be totally over. Also, you and your fiancé must intend to get married with one another within 90 days of you coming to the United States. Another requirement is that you must have met in person, you and your fiancé, within the last 2 years. However, if for whatever reason you couldn't meet in person, there might potentially be an exception that would allow you to forego this requirement that you met in person. So again, that's basically the big picture overview of how the fiancé visa works. It allows a US citizen to bring their fiancé to the United States so that they could get married once the fiancé is in the United States. So the next option that I want to talk to you about is a marriage-based green card. Now, I'm sure many of you have already heard about marriage-based green cards, but basically the gist of it is that if you are married to either a US citizen or a lawful permanent resident, a green card holder, then you could potentially qualify for a green card for yourself based on your marriage to the US citizen or the green card holder. Now, in order to qualify for this, you must be in a bona fide marriage. What this means is that at the time you and your spouse got married, you must have intended to build a life with your spouse. You cannot just be getting married for immigration benefits. Again, this is a marriage-based green card, and it can potentially work whether you are outside of the United States or whether you're in the United States, depending on the circumstances. So now that we talked about the fiancé and marriage-based options, I want to move on to additional options for somebody to qualify for a green card based on a family relationship to either a US citizen or a lawful permanent resident. So if you are the parent of a US citizen that is at least 21 years old or older, you could also potentially qualify for a green card through your child that is, again, a US citizen that's at least 21 years old or older. You can also potentially qualify for a green card based on being the child of a US citizen. So if you're the son or daughter of a US citizen, you can also potentially qualify for a green card by having your US citizen parent petition for your green card. You can also potentially qualify for your green card based on being the child of a lawful permanent resident. So if one of your parents has their green card, you could also potentially qualify for your green card by having your parent file an immigrant petition on your behalf. Now, again, if you're the child of a lawful permanent resident, in order to qualify, you must be unmarried. Another way that you could potentially qualify for your green card is having a US citizen sibling sponsor you for your green card. So again, if you have a US citizen brother or sister, they can potentially sponsor you for your green card by filing an immigrant petition on your behalf. in order for your sibling to file a petition on your behalf, they must be at least 21 years of age or older. So I want to talk about one additional option to be able to potentially qualify for your green card based on a family relationship to either a U.S. citizen or a lawful permanent resident. And this option that I want to talk to you about is called VAWA, the Violence Against Women Act. And basically, this is a special law for people, either men or women, that have suffered abuse at the hands of a U.S. citizen or a lawful permanent resident. Now, in order to qualify, you generally must either be the spouse or the child of an abusive U.S. citizen or lawful permanent resident. And in some cases, you could potentially qualify as the parent of an abusive U.S. citizen if certain conditions are met. Now, there are multiple requirements for VAWA, but essentially what you need to show is that you suffered either abuse or extreme cruelty at the hands of an abusive U.S. citizen or lawful permanent resident, that you had one of these relationships with, either a marital relationship, or that you were the child of an abusive U.S. citizen or lawful permanent resident, or again, if you were in some cases the parent of an abusive U.S. citizen. And through VAWA, somebody can potentially apply for their own green card. They could basically apply for their green card on their own without the need for the help of their abusive spouse or parent, or in some cases, child. So there you have it. In this video, we went over multiple ways that somebody can qualify for a green card based on having a certain family relationship with either a U.S. citizen or a lawful permanent resident. We talked about the Fiancé Visa. We talked about marriage-based green cards, whether it be marriage to a U.S. citizen or lawful permanent resident. We talked about ways for the parent of a U.S. citizen to potentially qualify for a green card, how in some cases the child of a U.S. citizen or a lawful permanent resident can qualify for their green card. We talked about VAWA for victims of abuse, and we also talked about how in some cases the sibling of a U.S. citizen can also potentially qualify for their green card. So I hope you guys learned a lot of valuable information from this video, and I hope that this helps you to understand some of the ways to immigrate to the United States based on having a relationship with a U.S. citizen or a lawful permanent resident. As always, thank you guys so much for tuning in, and I will see you on the next video.